Our next speaker, Professor Aderson Francois, is the supervising attorney for the Civil Rights Clinic at Howard University School of Law. The Civil Rights Clinic is a place where we are really have an opportunity to incubate these future social engineers. They are steeped, it is an opportunity to be steeped in constitutional law and other areas of the law, but I'm going to now turn it over to Professor Francois to talk about Howard's role in the case of the Cuban Fund.
Good evening. The Civil Rights Clinic got involved in the Cuban Fire case back in 2008 at the request and urging of then Dean Schmoke. But I must confess that when the Dean originally called me and asked me to consider this case, I actually did not want to get involved in it because on first glance, the case appeared to be, at best, a criminal law case, or at worst, a diplomatic dispute taking place in the court system, and I couldn't figure out initially why it is the Dean was asking me to get involved in the case as a civil rights lawyer. But the more that we looked at the case, my students and I, the more we became convinced of how important the civil rights case, the Cuban 5 matter, was. And I want to take a moment to explain at least our perspective on the case and why we believe it is such an important civil rights issue. As you recall from the prior discussion this evening, when the Cuban 5 went to trial, they went to trial in Miami, and among the pretrial motions that were made in the case was a motion to change venue. The motion was denied and the trial took place and the defendants were convicted. Ultimately, the lawyers for the Cuban 5 attempted to have the Supreme Court consider a host of issues in the case and moved for cert. And one of the issues that came up in the move for cert that we chose to focus on was the change of venue. Because our basic argument in the case was that it was impossible in the cultural and historical milieu of Miami at the time for the Cuban 5 to receive the fair trial. Since at least 1940, the Supreme Court of the United States has recognized that in order to receive a fair trial, a criminal defendant must be tried by a jury representing a fair cross-section of the community. And since at least 1975, the court has elevated that principle to a constitutional requirement. And the court has explained that the fair cross-section requirement is necessary because the purpose of a jury is to guard against the exercise of arbitrary power and to make available the common sense judgment of the community as a hedge against overzealous or mistaken prosecutor, or in preference to the professional or perhaps overdetermined judgment of a biased judge. However, the court has also understood that it is impossible for someone to receive a fair trial from a cross-section of the community if, in fact, the jurors are drawn from a community that is warped by prejudice, awed by violence, menaced by the virulence of public opinion, as manifested in explicit biased judgment or implicit biased judgment. And viewed from that perspective, it is not difficult to understand why it is that the Cuban 5 couldn't possibly receive a fair trial in Miami. Colonel Richardson, a moment ago, compared the trial in Miami, Florida, to an instance of Israeli security agents being tried in Tehran. What I want to suggest as an alternative analogy, and it is the analogy that we presented in the brief, though I want to do so carefully, is that asking for the Cuban 5 to receive a fair trial in Miami at the time would have been akin to presuming that, in fact, a black defendant, a black male defendant, accused of killing a white individual, or a black male defendant accused of sexually assaulting a white female individual could have received a fair trial in the Jim Crow South. Indeed, many of the cases that the court developed on the doctrine of fair cross-section got developed in the context of Jim Crow, where time and time again, black defendants were tried by white juries while a mob was waiting at the courthouse door. And my purpose here is not to suggest that Miami, Florida is the historical or more equivalent of the Jim Crow South. Rather, what I want to suggest is that the conditions that existed at the time were also present in Miami. Namely, you have the presence of a seemingly despised minority. You have the use of violence by French groups to oppress that minority. You have the toleration of that violence by mainstream society. And you have the suppression of any dissenting voices who dare to suggest some alternative. And these four conditions I want to suggest that were present in the Jim Crow South and that made it impossible for black defendants to receive a fair trial and therefore necessitated for the Supreme Court to overturn their convictions time and time again, and as a result develop the cross-section doctrine, were also present in Miami, Florida. The fact of the matter is, there are times when it seems as if life in Miami, Florida, at least at the time that the defendants were being tried, sounds like an echo of the poet Ovid when he was sent in exile from home, who claimed that exile was death. And for many members of that community, they believe quite sincerely that their life here in the United States since the Cuban Revolution is akin, if you will, to what Dante described in the Divine Comedy, that being sent away from home is like leaving behind every single thing that you ever loved. And the fact of the matter is the passing of the years seem to have done nothing to dampen that feeling. It is not a sign of indifference to the sincerity of what the Cuban American community in Florida believe about their exile from home, nor is it even a point of disagreement with their political cause. To suggest, rather, that the passion at the time in that community, the passion in that time, in that place, made it no more possible for these defendants, regardless of what one thinks of the Castro regime, made it no more possible for these defendants to receive a fair trial than it was possible for black defendants to receive a fair trial in the Jim Crow South. And I think it is for that reason that even though the case hasn't been really a case that's at the forefront of most civil rights organization, it does remain today one of the most important civil rights cases that the United States right now has to grapple with. Thank you.